If a contract doesn't technically violate the criminal law, but seems offensive to public morality, is it still enforceable? A federal court considered that question in Walters v. Fullwood. Brent Fullwood played on the Auburn University football team and was expected to go pro thereafter. At some point during his senior year, Fullwood signed an agency contract hiring World Sports and Entertainment Incorporated to negotiate Fullwood's contract with the National Football League. Norby Walters and Lloyd were World Sports officers and shareholders. The agreement was dated January 2, 1987, the day after Fullwood's last game as an Auburn Tiger, and the first day Fullwood could sign an agency contract without forfeiting his collegiate amateur status. But the previous August, while Fullwood was still a college player, World Sports paid him $4,000 in exchange for a promissory note, giving Walters and Bloom a security interest in any pro contract that Fullwood might enter into. Over the course of the 1986 college football season, Walters and Bloom sent an additional $4,000 to Fullwood or his family. The court would later conclude that the parties signed the agency agreement during the football season, perhaps at the same time as the promissory note, then postdated the agreement to avoid forfeiting Fullwood's amateur status and eligibility to play at Auburn. Shortly before the 1987 NFL Spring Draft, Fullwood repudiated his agency agreement with World Sports and hired Alabama lawyer George Kicklighter as his agent. The Green Bay Packers drafted Fullwood, and Kicklighter negotiated Fullwood's contract. Fullwood began his pro career with the Packers that fall. Walters and Bloom sued Fullwood in New York State Court for repayment of the promissory note and for breach of the agency agreement. Fullwood removed the case to federal court based on diversity of citizenship, then moved to dismiss the lawsuit.